Ready, start. It is not obligatory for the judge at that stage of the trial to consider in any detail and weigh in a sensitive balance whether the facts, if proved, would be incompatible with the innocence of the accused or not, full stop. The standard of test and judgment which is to be finally applied before recording a finding regarding the guilt or otherwise of the accused is not exactly to be applied at the stage of deciding the matter under section 227 or section 228 of the code, full stop. At that stage, the court is not to see whether there is sufficient ground for conviction of the accused or whether the trial is sure to end in his conviction, full stop. Strong suspicion against the accused, if the matter remains in the region of suspicion, cannot take the place of proof of his guilt at the conclusion of the trial, full stop. But at the initial stage, if there is a strong suspicion which leads the court to think that there is ground for presuming that the accused has committed an offence, then it is not open to the court to say that there is no sufficient ground for proceeding against the accused, full stop. The presumption of the guilt of the accused which is to be drawn at the initial stage is not in the sense of the law governing the trial of criminal cases in France, where the accused is presumed to be guilty unless the contrary is proved, full stop. But it is only for the purpose of deciding prima facie whether the court should proceed with the trial or not, full stop. If the evidence which the prosecutor proposes to adduce to prove the guilt of the accused, even if fully accepted before it is challenged in cross-examination or rebutted by the defense evidence, if any, cannot show that the accused committed the offence, then there will be no sufficient ground for proceeding with the trial, full stop. An exhaustive list of the circumstances to indicate as to what will lead to one conclusion or the other is neither possible nor advisable, full stop. We may just illustrate difference of the law by one more example, full stop. If the scales of pan as to the guilt or innocence of the accused are something like even at the conclusion of the trial, then, on the theory of benefit of doubt, the case is to end in his acquittal, full stop. But if on the other hand, it is so at the initial stage of making an order under section 227 or section 228, then in such a situation ordinarily and generally the order which will have to be made will be one under section 228 and not under section 227, full stop. This court had an occasion to consider in detail the scope of the proceedings at the stage of framing of the charge under sections 227/228 CRPC, full stop. After considering earlier decisions of this court on the point, thereafter in paras 29 to 31, this court has observed and held as under colon within bracket SCC pages 721-23 bracket close double inverted comma 29 dot. We have bestowed our consideration to the rival submissions, and the submissions made by Mr. Ranjit Kumar commend us, full stop. True it is that at the time of consideration of the applications for discharge, the court cannot act as a mouthpiece of the prosecution or act as a post office and may sift evidence in order to find out whether or not the allegations made are groundless so as to pass an order of discharge, full stop. It is right that at the stage of consideration of an application for discharge, court has to proceed with an assumption that the materials brought on record by the prosecution are true and evaluate the said materials and documents with a view to find out whether the facts emerging therefrom taken at their face value disclose the existence of all the ingredients constituting the alleged offence, full stop. At this stage, probative value of the materials has to be gone into, and the court is not expected to go deep into the matter and hold that the materials would not warrant a conviction, full stop. In our opinion, what needs to be considered is whether there is a ground for presuming that the offence has been committed and not whether a ground for convicting the accused has been made out, full stop. To put it differently, comma, if the court thinks that the accused might have committed the offense on the basis of the materials on record on its probative value, comma, it can frame the charge, semicolon, though for conviction, comma, the court has to come to the conclusion that the accused has committed the offense, full stop. The law does not permit a mini trial at this stage, full stop.